Hello guys, my name is Amit Sani and I welcome you in this daily Hindu announced video in the morning. These videos come in the evening, the PIB videos come. In today's paper, there is no information, there is no article, and all are political ones, so not important for our examination. But I have selected some information, so a small lesson with some important details for the prelims examination we are going to discuss here. And from 3rd of June, these lessons are going to be very much a standard one with much detail and mains oriented, prelims oriented in both ways. These are going to be very important. But before that, these lessons are totally for the prelims aspirant this year. Okay. So the people who are appearing next year or next year, they would be continuing these lessons. And for the people who are going to appear in this 2nd June examination, for them also these lessons are very important. So questions, data, and some prelims oriented facts. Let's start. These are the numbers there. You can call and you can ask for these pen drive courses, and all are available at 60% off, and chat section is available. Any kind of query, any kind of confusion, you can ask here. Now, women still underrepresented in science and technology. UNESCO and Microsoft Asia, they both gave this important report. And STEM is science, technology, engineering and math. They may ask you about this abbreviation and this area, where they're saying that the numbers of females, that is very less, and these numbers, they are showing a imbalanced picture there. UNESCO says in science and technology around 29% only numbers are there for the girls and maybe for the women, and as low as 19% in South and West Asian region, and that's a big cause of concern. And it's good 48% in Central Asia, but not more than 50%. And Microsoft also launched a particular initiative to encourage women to pursue careers in STEM and the technology major, and they have been working for that. You see, it's a major issue. You see, conventionally the medical field or the teaching field or some other important areas, they are held as very much comfortable and suitable for the girls to do a job. But now this tradition is changing, and we cannot decide this thing about girls or women. It is they who are gonna decide about this issue, and these traditions are being broken now, and they are more and more challenging all the fields. Yesterday we learned the first lady who is now eligible for flying these combat planes during the wars. So these are important challenges being given to males by the females today. But this area which is lagging here now, the things they should be improved here also. Next, MOU signed between DBT and DAE, Department of Atomic Energy and Department of Biotechnology. This is under Ministry of Science and Technology, and this is directly under PMO. Now they both are signing an agreement for the joint collaborative research in the medical field mainly. You see, in the cancer research, radio therapy is a very important therapy. There they use these radiations, and in some testing and diagnostics also some radioactive materials, substances are used, and many instruments like Geiger-Müller counter and all, they are used to count these radiations which are entered with these substances for the testings and diagnosis of some problems there. And in specific cells where we need to burn these cells in the end, then there also this radio therapy is used. So a lot of research is needed in this unsolved area, because we do not have a perfect cure for cancer, and many number of people, and one of the most numbers of the people who are killed by this disease, and it's a most dreaded disease. That's the problem. It kills the person in a lot of fear and agony. So that's why it's a very dangerous disease. So we do not have any solution till now, and some help is available in previous stages, but later in the later stages only the radiotherapy can be a solution there. And here you see this cancer research issue that is going to be raised here. It will be prioritized. Affordable technology, affordable issue is a very important issue here, because cancer research and cancer therapy and medicines and all these particular techniques, they are very expensive ones, so not approachable for the poor. So that's why the extensive research is needed there to develop the affordable technologies, and clinical trials and all, they all are going to be based on this. And you see DAE is represented by Tata Memorial Center, which is also functioning as coordinating with the center on behalf of National Cancer Grid of India, which is the grid of institutions involved in cancer research. So they may ask you about this data importantly. Next, Pak test fires ballistic missile Shaheen 2. As I told you, ballistic missiles moves in this way. This is the ballistic path, and the cruise missile that moves parallel to the surface, and the height also is very less with that. But here the height is too much, and the range is also in thousands of kilometers. This Shaheen 2's range is 1500 kilometer. As you see, India's intercontinental ballistic missile program is going on, and Agni 5 is the intercontinental ballistic missile. So that goes in the ballistic path. So that's like this Shaheen 2, that is also a ballistic missile. And like BrahMos, as I told you about that yesterday, BrahMos is a cruise missile. So cruise missile and ballistic missiles, these are ballistic missiles. When we need to throw them more than 1, 2, 3, 4, 5,000 kilometers up to 10,000 kilometers, then the ballistic missiles are used there. Next, about the Assam Rifles. Assam Rifles, India's oldest, not youngest paramilitary force. As I told you, important forces are there like CRPF, BSF and all. These are paramilitary forces, and they are different from our important armed forces. And 46 battalions deployed at Indo-Myanmar border in northeast area, and countering the insurgency in that particular region that is very much sensitive. That's the major work there. So only 2 is the correct answer, 1 is wrong, because it is the oldest paramilitary force, and 3rd Naga military force, this battalion is the oldest battalion there. 3rd Naga Hills Battalion, that's the oldest battalion there. Okay, and this news was regarding the Assam Rifles and the Indian Coast Guard. Indian Coast Guard come under Ministry of Defense only, but that's also a different one from Indian Navy. Remember that. So these two are coming under this affiliation charter between the 3rd Naga Hill Battalion of Assam Rifles and Indian Coast Guard ship Shaurya. So they two are doing this agreement, and it is going to be important. And you see, there is a specific name. In the Andaman Nicobar Islands, I told you about the Andaman group in the north and the Nicobar group in the south. And there is South Andaman Island, that is the most important one, biggest one, and there this Port Blair capital is located. And west to it, there is North Sentinelese Island. There these Sentinelese tribe lives. That is uncontacted, most mysterious tribe in this world. And they are very aggressive people. There has been no contact with this tribe. So this is a very specific island. So in the name of it, they call Assam Rifles as Sentinelese of Northeast, and the Indian Coast Guard, that is called Sentinels of Seas. So these two again are very much famous with these names. So that's why that's very much highlighted. So they may ask questions regarding that. So remember that. Next, Competition Commission of India is the statutory body, perfectly correct, established under the provisions of Competition Act of 2002, enforced in 2003. So that's important. But second is not correct, because it is not working for the export capability or something like that. Mainly it is working for the healthy competition between the companies. It is checking any kind of agreement if it is there which is going to distort the market, or if any company that is going to dominate the sector there, and it is crushing the other companies and all, and consumerism is not going to be maintained after that, and this company is going to dominate the market, then it works against that, and it takes steps against that company or some particular group. So it maintains the healthy system of competition in the market. So for that it works, and more than 600 cases it has taken till now. Only one is the correct answer, second is wrong here. Next, Supreme Court gets full strength of judges. As I told you some days back, that 27 is the present strength and 31 is the maximum strength there, and 30 plus 1 as we call it, because CJI is 1 and 30 are Supreme Court judges. And now important is that their retirement age is 65 years, as we all know. And these four new judges, Justice Anirudh Bose, Justice Suryakant, A.S. Bopanna and B.R. Gawai, they are new additions, and now the strength is full. Issue is that regarding Bose and Bopanna, which are coming from Calcutta High Court, Guwahati High Court and Karnataka High Court, central government had some reservations regarding their names, and they were not clearing their names. So now they have cleared all the names. The notification by the law ministry is out, and now according to the set procedure of the collegium system, as once the collegium system sends this to central government, then the law ministry announces this notification, and now president has been told about this. Now president is going to appoint these judges to the Supreme Court's group there. So now 31 judges will be there, and one specific case of Justice B.R. Gawai. He is the only Supreme Court Dalit judge, is coming from the Dalit community. So he's the only Supreme Court judge there, and he's coming from Bombay High Court, and he may become the next CJI. Dalit CJI means not the very next, maybe in the future he will stay till 2025, and at that time, in May 2025, he may become the second Dalit CJI after KJ Balakrishnan, who got retired in 2010 in May. So after 15 years, he may become the second Dalit CJI of India. So that is a very important thing for this country. Okay, next, these are 4 important personalities who are appointed as Supreme Court judges, and he is B.R. Gawai, and he is Anirudh Bose and Bopanna. Regarding to, there were some issues. Now PMLA, the Prevention of Money Laundering Act, we will discuss all details regarding that because it is very, very important. Many issues they appeared in the news regarding that. You see, it was there when High Court decided about a case where it said that PMLA prevails over Bankruptcy Act and Insolvency Codes, because according to the new norms of IBC, Insolvency and Bankruptcy Code of 2016, according to this code, it's allowed that they can attach these properties and all, and very strict provisions are there against the offenders, because the recovery case is going on, and the NPA crisis is too huge, and IBC is the main instrument that is working now, and somehow it is taking slow steps, and some success it has got till now in the NPA crisis. So in a case where Enforcement Directorate had challenged the order of a PMLA Appellate Tribunal, and now High Court has decided this case about that PMLA will prevail if any kind of issue of attachment of the property and their auction and all, where PMLA Act would prevail. This is Prevention of Money Laundering Act of 2002, enforced in 2005. So that's the case. And here the court said that IBC, SURFACE Act and RDBA Act, these should remain in harmony, and they should act in a cooperative way. SURFACE Act is also very, very important in this area of NPA crisis, where the recovery of the assets is a important theme. We should know the abbreviation here: securitization and reconstruction of financial assets and enforcement of securities interest. Okay, so this is SURFACE Act that came in the starting years of last decade, and IBC came in 2006, and RDBA is the old act. Now Delhi High Court set aside the verdict of PMLA tribunal and held that objective of PMLA being distinct from the purpose of RDBA, SURFACE and IBC Act, that will prevail, because it is regarding the money laundering issue mainly. Okay, so it applies to many issues and many ranges, and here these acts are mainly for the recovery issue and dealing with companies and banks. So that's the case. And the attachment order under PMLA will not be illegal only because a secured creditor has a prior secured interest in the property. So they say that if that person has stashed a lot of black money, and if that person has collected many properties and assets, so if they are coming out of some money laundering issue or some black money issue, then these are severe provisions. So that's why the PMLA Act that would prevail here. Okay, so that's important, and it's very, very important for us to know about the PMLA Act. It was enacted by the NDA government in 2002 and was enforced in 2005. And you see, they are actually giving effect to its provisions and reporting to Financial Intelligence Unit India, FIU India. That's a very important one. You see, this act was amended in 2005, 9 and 12 also. And issue is that this Financial Intelligence Unit that is responsible for getting data regarding all the transactions or any kind of requirement in financial issues, or the analysis of financial transactions, that is the main theme of it, and for that it is working. It is reporting to Economic Intelligence Council headed by Finance Minister of India. So the bigger body is EIC, and this FIU in India is reporting to EIC. And you see, now some provisions are there, and an important decision came by Supreme Court, where before that particular verdict, according to PMLA Act 2002 and the Section 45, it became nearly impossible for that person, the accused person, to get bail in this case. Now, according to the Article 14 and 21 issues, where the equality concept is there and the right to life and all these rights case is there, here Supreme Court said that it's against these important provisions and they are being violated here, and opposing the bail will not be absolute here. And now if we talk about the objectives of this PMLA Act, then it seeks to combat money laundering issue in every case. So the money laundering is the main issue, and regarding the policy making, regarding the knowledge of this issue in the public domain, and it is helping the government and preventing and controlling the black money and money laundering here. Next, the definitions which are important here, and they may ask you directly about these definitions here. Attachment. What is the attachment of the property here? They may ask you directly about that. Prohibition of transfer, conversion, disposition or movement of property by an appropriate legal order. So legal order is important here. Next, proceeds of the crime. Any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. Means this should be a scheduled offense, and there must be provisions regarding that, and it should be a criminal activity. And then all these properties which are obtained or anyhow they are directly or indirectly they are created, then they will be counted as proceeds of the crime. And money laundering is based on this particular definition, where whosoever directly or indirectly attempts to indulge or assist other person or actually himself involved in any activity connected with the proceeds of the crime, and this untainted property is involved there, then it will be called the case of money laundering. So this definition is very important. Payment system is also the important part of it, where that is the basis of all these financial transactions and all these money laundering issues. So that's important. Next, salient features here. 3 to 7 years maximum imprisonment is given as a provision here, and it is going to be the rigorous imprisonment in this particular money laundering issue. Next, if the 1985 Narcotic Drugs and Psychotropic Substances Act provisions are also applicable here, then the maximum punishment is now raised to 10 years from 7 years. And powers of attachment of tainted property, that is also lying with the appropriate authority. There is going to be an adjudicating authority, and central government, the government of India, is going to decide about that, and they may attach properties for the provisional period of 180 days till the time the case is solved. Okay, and this adjudicating authority, that will be based on the principles of natural justice. That's important. You see, the NGT, National Green Tribunal, that is also not following the Code of Civil Procedure 1908, and it is based on the natural justice issue. So in the same way, natural justice would be applicable here. So there may be some differences in the Civil Procedure Code and the natural justice issue. Mostly these are same, because this Code of Civil Procedure is also based on the natural justice issue, and that was created a long time back. But now this natural justice issue is very specific here, because cases can be very unique here, because loopholes are always used, and many sensitive issues, bigger issues of the economy, they can be involved here. Next, burden of proof would be lying on the accused. It will be not on authorities, importantly, and that's a unique case where the accused person will have to show the proof that his properties are lawful. Why this is done? Because in these cases of money laundering, always rich people are involved, and with a general observation only they can know, and they can have a particular idea about their properties, and that these can be legitimate or not. So always the person has to show these proofs that the properties which he wills, these are lawful properties. So the burden of proof is important here. Appellate tribunal. You see, we talked about the adjudicating authority, which will be decided by the government of India. In the same way, there is going to be an appellate tribunal for that. If the verdict of the adjudicating authority is not accepted to some party, then they can appeal here in this appellate tribunal, and this tribunal is as a body appointed by government of India again. So everything is lying with the central government here. So everything is dependent on the central government ultimately. And here you see, If the appellate tribunal verdict is also not acceptable, then that person can move directly to the High Court or next Supreme Court. So that's important case. Next, there is going to be a special court also, the third one. According to the section 43 of the PMLA Act, there is going to be a special court, and in consultation with the Chief Justice of a High Court, Government of India, the central government, they can designate one or more courts of session as a special court. Okay, so Sessions Court would be taken as a special court here. And regarding this FIU and END, as I told you, it is gonna report to Economic Intelligence Council, EIC, the bigger body which is headed by Finance Minister here. So a lot of things are lying with the authority of central government. So if the central government is involved in a wrong way somewhere, then you can imagine what kind of consequence can be there on the total system here. Next, RTI Act supersedes Official Secrets Law. This Official Secrets Law came in 1904. After that, the new replacement came in 1923. So it's a very old act. It is a British era act, and at that time they wanted to crush all these newspapers who were revealing the truth of the British government. So at that time, just to muzzle those newspapers, this Official Secrets Law that was brought up. And now in the Rafale issue, when this OSA was proclaimed against the Hindu newspaper, the same newspaper we are discussing every day, because it published all those documents in the original form. So they raised this issue, but now Supreme Court is clarifying on this issue. Justice K.M. Joseph says that RTI is the most pertinent one, and it came in 2005 with all the observation and the experience, and it is very much important for the democracy and for the people to know about all the details. Maybe they are relatable with the national security issue. If these are core issues, then these are not allowed even in the RTI also. But the allowed issues, they should be open to the public here. And here Justice Joseph said that the Right to Information Act overawes the OSA Act. So that's important. Okay. About this OSA, as I told you, in 1904, during the time of the Lord Curzon, he remained there from 1899 to 1905, and he was responsible for Bengal partition also. And just to muzzle the voices of the nationalist publication, this was used here, and now it was again used by the present government in the independent India. Okay, it related with the two aspects of spying or espionage. So section 3 is dealing with that, and you see they may ask you about the secret information clause also. This can be any official code, password, sketch, plan, mode, article, note, document, or information, anything. Okay, they can be taken as secret information. And this colonial climate was there, and that's why this is not relevant today, and many suspicions and many arguments are there against this Official Secrets Act, and it says it has no relevance today in the age of Right to Information Act, and that is the most important one now. But many situations are going against the democratic right of knowing the information. So this is the main question. The people who are appearing on 2nd June, they may write it on 3rd June, and other people, they may write it today. So we'll meet again in the PIB lesson in the evening. All the questions we are going to discuss there, so please come back in the PIB lesson also. And in the evening around 5 o'clock or 4 to 5 o'clock, these videos are available, PIB videos. So thanks a lot. Keep watching. It is Amit Sain.